Larry here from 7 Sage Law School Prep, and another stick figure exam tip. This one is part of Master Your Professor, one of the 3 prongs of our study strategy. And it's called Know Your Professor Part 1. As G.I. Joe used to say, knowing is half the battle. Actually, it's just a third of the battle according to our strategy. But it's important to know your professor. Not in a general way. There's a way to divide professors. One very crude way, but it's effective, is to divide them into 2 worlds. The ivory tower and the mean streets. That is, you've got your PhD, supreme, court clerk, professor here, and down here you've got a long-time practitioner professor, someone who's been a litigator for like 20 years, chasing a giant mutant piranha down the street with his Professor Wifflebat. Now, professors seem to be conscious of this division. Professor Thomas Bergen some years ago wrote, I think in Vanderbilt Law Review, an article about the dual role that professors have at a law school. They're both academics who do research and think interesting thoughts about the law, but they're also Hessian trainers. They're supposed to be providing legal training. This specific distinction is a little bit less relevant for you. Bergen was a professor writing for other professors about the duality that professors had inside of them. But as time has gone on since Bergen's article, I think law schools are pretty split between people who've had very high-level credentials but very little practical experience, and professors who may have impressive credentials still, but not these theoretical ones. They've actually fought day-to-day as litigators. One generalization is, while every law school, except for perhaps Yale, has some combination of these, the proportion of ivory tower professors are likely to be higher at a higher-ranked law school. And as you kind of go down the U.S. News rankings, you're more likely to get these sort of mean streets professors. But what does that mean for you in terms of actually being able to learn to really read your professor? There are some general thoughts that apply to different types of professors and different strategies that you'll want to employ based on this crude division. With an ivory tower professor, you can be more creative. They really don't know the difference in the real world between what works and what doesn't. They were a clerk, they've seen very high levels of argumentation, but they're much more into legal creativity. With a mean streets professor, you want to be careful. That creativity has to fall within what that professor, who's been in the real world and has fought mutant piranhas, understands to be possible. So you have to be creative within the bounds of legal practice. Of course, the paradox is that you've never been in legal practice unless perhaps you were a paralegal before law school. I think that legal practice means something very particular on law school exams with longtime practitioner lawyers. They expect you, whether or not you're actually taking them for a civil procedure class, to have some sense of procedure. For instance, I had a torts professor who was very much into standards that we weren't even studying in Civ Pro at the time. Things like summary judgment or decision notwithstanding the verdict after a jury trial or motion to dismiss. Now, at the moment, this may sound like gobbledygook to you, but the short thing to understand is that the professor wants you to make decisions about claims based on what actually makes sense for a lawyer to pursue. Again, the paradox is you don't actually know what a lawyer would do, but criticism that a professor might provide on such an exam is, why would you file such a motion? It's a waste of money for the client. That's a real criticism that I saw a Civ Pro professor who'd worked at Public Citizen for like 30 years litigating cases. So one thing that may help with these professors is to understand these concepts, these very particular concepts in civil procedure. These are legal standards that apply to whether or not a case should be thrown out before you even get to trial. That's important because it speaks to the level of evidence or the level of argumentation that is or isn't BS according to that law professor. There's a lot more to say in terms of what works within the ivory tower. There are different types of professors within the ivory tower, those who have a literary bent, who come from more of a literary criticism kind of background, versus a law and economics professor. You can't say the same things to them. At NYU, there were two different law professors, both named Adler. One was Amy Adler, who wrote mainly about child pornography and sex and art and the law, and Barry Adler, who went to the University of Chicago, clerked for Frank Easterbrook, and had a very law and economics view of contracts. Amy Adler and Barry Adler did not teach contracts the same way, even though they're from the ivory tower. Similarly, within the mean streets, you might get different kinds of professors, some who were longtime litigators, some who were longtime defense litigators, and some who were plaintiffs' attorneys, some who worked at a state AG's office where they may not understand the constraints and costs for real-world clients. We can get into this in another edition of Know Your Professor.